The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we're going to discuss the types of evidence and relevant factors considered in child custody cases in Illinois. So television and movies make child custody cases and child support cases look like knockdown, drag-out battles that bring out the worst in the parents, and sometimes they are. The prospect of not seeing your child as much as you'd like can be quite disconcerting, obviously. So ideally, when going through a divorce and determining how parenting responsibilities will be divided, both parties will come to hopefully an amicable agreement that is in the best interest of the child, sparing both parties from unnecessary grief and pain. But when the two parties disagree, the court must ultimately determine what would be in the child's best interest, right? So during the litigation process, many different types of evidence may be presented, from financial documents and health records to testimony from a bevy of witnesses. Even your social media posting could come into become evidence in a child custody case. So some of the more common types of evidence presented during a child custody case and relevant factors for the court to consider are going to include things like the wishes of the child's parents. So it may seem like a no-brainer that each parent would want their kid to have the most time with them, but there are plenty of examples when one parent feels their child shouldn't be maybe around the other parent at all, or should only be around the other parent, let's say in the presence of another guardian, such as like a grandparent. Next, we have the mental and physical health of all parties involved. So this information may come in the form of health records, interviews with treating physicians, and other testimony. Again, the big one, obviously the wishes of the child, usually irrelevant of the child's age unless the child is an infant and unable to communicate his or her intentions in a meaningful way. The court will consider the wishes of the child when determining custody. Another big source of evidence is social media. So social media is becoming more and more integrated into our lives in ways we don't even know and can't really predict. So it's nearly become background noise a lot of times, in the same way, we get home and we turn on the TV in the morning when making breakfast. Posts on any form of social media, from Facebook to, self-deleting apps such as Snapchat, can be included as evidence in a child custody case. Then there's the history of physical or emotional violence in all parties involved. This one pretty much goes without saying, but a history of violence does not really lend itself well to winning a child custody case. Next, let's talk about writings. So writings covers just about everything from letters, photographs, emails, words, pictures, etc. This is where a significant amount of evidence will come from in a child custody case, and where a case is pretty much made or broken, right? So you might have a photograph of your ex taking part in a negatively viewed behavior during a time that your ex told the court they were with your child. Or perhaps you have a text or email from your spouse stating ill intent towards you or your children, whether true or just hyperbole. Writings are also a common area to catch the opposing party in a lie, and under the penalty of perjury, it would look very bad for the lying party and would call into question the truth of every other argument in support of his or her side. However, in order to have any form of written evidence introduced into the case, it must be authenticated, meaning you have to establish a chain of custody showing who had the evidence and when, prove that your evidence actually shows what you say it shows, and prove that your evidence will assist the court in its decision and not be misleading. There's also what level of willingness does each parent show in facilitating a close and healthy relationship with the child and the child's relationship with the other family members. Also, there's whether either parent is a sex offender and other history of criminal activity. And in the case of one or both sides being military parents, the military family care plan must be completed and presented in the case. Now, objections from the opposing party can be made to nearly any piece of evidence. Typically, you may have a feeling if some piece of evidence is objectionable, and you would discuss this with your lawyer. He or she would determine the proper objection, and that piece of evidence would be considered for removal from the case. So some typical objections include no personal knowledge. So again, this is like perhaps your ex-spouse is testifying about an event or another piece of evidence that he or she was not present for or has not seen. Second, there's hearsay. That's secondhand written or verbal statements like his brother said that he always drinks around the kids, Third, we have improper or no authentication. So a piece of evidence such as a message in a text thread presented without the entirety of the thread. As you can imagine, it would be easy to present a single message, take it out of context, and suggest it applies to whatever position you're trying to prove. And then fourth, we've got irrelevant, ambiguous, or misleading evidence, right? So that's a piece of evidence or a question about a piece of evidence that doesn't make sense to you, is deliberately meant to mislead or confuse you, or is unduly prejudicial and doesn't support the facts or main argument trying to be proven. So evidence is really what makes a case, and knowing what to include and how to manage objections is an integral part of your lawyer's job. There can be a lot of back and forth in custody cases, and being knowledgeable and prepared with the proper legal help can be the difference between winning or losing a case. So for more information on Illinois child custody, check out our other articles and videos on Learn About Law. Thanks for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.